Dear ladies and gentlemen, it is both a great pleasure and honor to welcome Professor Anthony Cassimatis in our lecture series. Professor Cassimatis is a professor at the TC Beirne School of Law, the University of Queensland, a very historic university in Australia, and he's the director of the Center for Public, International and Comparative Law at the same alma mater. He is teaching administrative law, public international law. Among other, he is also very much into matters of international humanitarian law, which can be underlined through the fact that he was the chairperson of the Australian Red Cross International Humanitarian Law Committee for a considerable wealth of time. His publishing palmarès are very impressive. He has been the author or co-author of 5 books and numerous articles and book chapters on the matters of law, which I've mentioned before. Besides that, he's also the editor-in-chief of the Australian International Law Journal, and he's been academic supervisor of teams representing his law school in the Jessup International Law Moot Court competition over many years. His main research interests, of course, include international law, administrative law, public law generally, and a matter of international law will be in hand for today's session. So with no further ado, I'd like to present Professor Cassimatis to you.
Thank you, Demetrius, for that kind introduction, and thank you to the organisers for the invitation to give the lecture. I will endeavour to share my screen, if that's is that visible?
Actually, now we're seeing our email. Yes, well, there you go.
Very good. Yes. Thank you. And the lecture is essentially attempting to understand the strategy that Ukraine and its allies are attempting to follow in respect of the aggression by the Russian Federation, which one can date from February of this year, but Ukrainians would say began in 2014. What I would like to do essentially is to go through the various, basically just see the lie of the land, to explain the various actions that have been brought, the various legal actions, also the various resolutions that have been passed, for example, in the United Nations General Assembly, actions taken by Ukraine, but also by other states, the Netherlands, Australia, and non-state entities. There have been various investor-state dispute settlement claims that have been brought. And I just want to set those out in general terms, and then to reflect on how international law can be used in a way to affect future action. It's common, particularly in the common law tradition, to sort of emphasize the role of courts and litigation, and that's important. But it's also, I think, often in national systems, one sees that participants in a legal system alter their behaviour, not just because they're parties to litigation, but because the law is set out clearly and they're aware of the circumstances. And so there's the capacity for a legal system to influence behaviour based on the sort of shadow that it casts, the effect that the law and its certainty might have on the behaviour of participants. And what I'm going to suggest in this lecture is, in fact, that phenomenon can be seen in international law, and part of Ukraine's legal strategy appears to be along those lines, in terms of the way in which an action in one context might influence other contexts and affect the behaviour of participants in a way that will advance the international legal rules that have been implicated by the war that is occurring in Ukraine. So, and I want to tease out some of the implications that flow from that, and then make some concluding observations. In terms of terminology, I've used the expression lawfare. That is, in some circles, a pejorative term. I'm not using it in that sense. I'm going to invoke one of the early users of the term lawfare, Major General Charles Dunlap, who indicated, I think quite appropriately, that it is a neutral term. It can be used to describe quite a legitimate use of law to achieve other objectives. It can also be misused. So I'm certainly not intending to connote some sort of negative position in relation to the Ukrainian use of international law, simply that it is a strategy that's being used, quite naturally used actually by a weaker power in a conflict situation with a more powerful entity. A rules-based approach essentially has a certain degree of attractiveness to a person or entity that's in a weaker position in other respects. And it's that sense in which I'm going to use the expression. I should say, if anyone has any questions, I'm also happy to take questions during the course of the presentation. The other sort of issue of terminology that I would like to just sort of make clear is that my use of the expression aggression against Ukraine is derived directly from the 141 states that voted in favour of the first emergency session resolution that was adopted by the General Assembly on the 2nd of March 2002. That resolution, which you are seeing on the slide, is entitled Aggression Against Ukraine. And so I think that position by the General Assembly is a correct legal analysis. The definition of aggression in Resolution 3314 seems quite plainly to have been satisfied. And so that's the terminology I will use. But if anyone has an objection to that, then you should take it up with the 141 states and the General Assembly in terms of that particular resolution. Now, turning to the various legal responses to the Russian Federation's aggression, there have been a range of resolutions that have been adopted by the General Assembly, and as I indicated earlier, the Ukrainian position, which I think is again one that I would agree with, that the Russian Federation's aggression actually began in 2014 with the military action seizing control in the territory of Crimea in 2014. And there have been a range of resolutions adopted by the General Assembly. The initial resolutions were adopted in the general sessions of the General Assembly, not in an emergency session. And those resolutions have done various things. So the purported annexation of Crimea in 2014 was condemned. States were called upon not to recognise that annexation. And then the more recent resolutions that have been adopted following the Uniting for Peace process, with an emergency session with the deadlock in the Security Council. The General Assembly passed resolutions after the invasion in February on various topics, initially in respect of the invasion, and then subsequently in respect of the invalid purported annexations of the various regions. And then most recently, on the 14th of November of this year, a resolution on reparation, which I think is quite important, and which I'll refer to again in a moment. So we have a range of resolutions adopted by the General Assembly, other institutions as well. The the Council of Europe, the Parliamentary Assembly of the Council of Europe, the OSCE, other bodies, but the General Assembly resolutions, I think, have been quite significant legally in ways that hopefully I will explain through the course of this lecture. Ukraine has also initiated a number of actions before various international bodies, and the two that I want to begin with are the proceedings that have been brought by Ukraine before the International Court of Justice. So there are two main actions that have been brought, two actions that have been brought. The first is an action that was brought after the seizure of Crimea, which was an action relying on the consent that the Russian Federation had given to dispute resolution under the International Convention for the Suppression of the Financing of Terrorism, and the consent the Russian Federation had given to dispute resolution before the International Court of Justice under the Convention on the Elimination of Racial Discrimination. So there was an action brought essentially relying on compromissory clauses in those two treaties. And the court in late 2019 rejected the objections that the Russian Federation brought in respect of the jurisdiction of the court and the admissibility of the proceedings. And so those proceedings are ongoing. The court is moving towards a judgment on the merits, having rejected the objections that the Russian Federation put forward in respect of those claims. And then following the invasion in February of this year, Ukraine relied on the compromissory clause in the Genocide Convention and quite ingeniously argued that the Russian allegations of genocide in the Donbass region created a dispute under the Genocide Convention, and the compromissory clause of the Genocide Convention is actually quite broad. It's not like a normal compromissory clause, which says that a court or the ICJ in this instance would have jurisdiction in relation to a dispute regarding the interpretation and application of a convention. It does more than that. It actually provides that the International Court of Justice has jurisdiction in relation to disputes regarding the interpretation, application, or fulfillment of the Genocide Convention. And the Ukrainian argument, in part, is an argument that Ukraine is fulfilling the Genocide Convention. It is not engaging in genocide. It has not engaged in genocide in relation to the Donbass region. And Russian accusations to that effect create a dispute under the Genocide Convention, which the court can exercise jurisdiction over. So the court dealt with the request for provisional measures and delivered a judgment. So jurisdiction hasn't yet been determined, but the sort of prima facie jurisdiction required for provisional measures jurisdiction was found on the 16th of March in 2020, earlier this year. Leaving the International Court of Justice, Ukraine also commenced proceedings in the World Trade Organization in respect of various restrictions that the Russian Federation imposed in trade relations between the Russian Federation and Ukraine. So movement of Ukrainian goods was restricted in quite significant ways, including transiting goods that Ukraine was seeking to have intended to be, for example, sold into Central Asian republics, etc. These were being interfered with. And so an action was brought by Ukraine against the Russian Federation, which is both Ukraine and Russian Federation are members of the World Trade Organization. And the Russian Federation invoked the security exceptions in the General Agreement on Tariffs and Trade, 1994, Article 21 in particular. And in 2019, a strongly constituted panel under the chairpersonship of George Abi Saab, the Egyptian international lawyer, essentially found that though Article 21 national security exceptions were not totally self-judging, so though there was a role for the panel in terms of assessing the Russian Federation's claim, there was a significant degree of discretion that the Russian Federation enjoyed. So in a sense, Ukraine was unsuccessful in those proceedings. Russia was entitled to rely on the security exceptions, and Ukraine wasn't able to succeed in its WTO claim. Now, this is interesting, though. The 2019 panel report, which wasn't appealed, so it is the final stage of that litigation, becomes important in terms of the response of states sympathetic to Ukraine to the February invasion, the invasion earlier this year, because essentially the G7 member states and other states supportive of Ukraine have essentially relied on this judgment to restrict Russian Federation's most favored nation status. So in a way, and this is sort of the theme, the indirect effect of the certainty that this judgment is given has effectively been beneficial to Ukraine. Turning to matters maritime, Ukraine, after the seizure of Crimea, Ukraine attempted to initiate procedures under the Law of the Sea Convention, under Annex 7 of the Law of the Sea Convention. And again, had a relatively unsuccessful experience before the arbitral body, which delivered its judgment in 2020. Essentially, the arbitral body, notwithstanding the resolution adopted by the General Assembly, calling on all states not to recognise any change in sovereignty vis-a-vis Crimea, the arbitral tribunal said it could not just accept the General Assembly's resolution and that it couldn't deal with the issue of contested sovereignty in respect of Crimea, which is obviously not what Ukraine would have hoped in respect of those proceedings. But we'll see as we look at some of the other judgments that have been given, and indeed in relation to disputes involving other states. I'm thinking here of a recent decision in a dispute over continental shelf rights between the Maldives and Mauritius. This judgment involving Ukraine and Crimea was distinguished in a way that I think will give some hope to Ukraine in respect of the way in which this litigation is progressing, but more on that in a moment. Now, in addition to those proceedings in respect of Crimea, there was also the seizure of Ukrainian naval vessels attempting to enter the Sea of Azov, and the detention of Ukrainian naval personnel, which resulted in various proceedings which I believe are ongoing. So they're also running as well, but they're separate from the action regarding the maritime delimitation Annex 7 arbitration that I spoke about a moment ago. So there are three essentially separate law of the sea related actions that are sort of either concluded or ongoing. Leaving maritime matters and turning to human rights, Ukraine has brought various actions before the European Court of Human Rights against the Russian Federation. Those actions have been consolidated, and there was an important judgment delivered, I think, in 2021. There's some uncertainty about the actual date of the judgment, which I will go into in some detail, because I think it shows how a legal system, in this instance international law, can, through decisions in one context, affect legal disputes in other contexts. And this is where I'm going in terms of this particular lecture. Now, leaving Ukraine and looking at other states, I mentioned that the Netherlands and Australia have also taken various actions which essentially are relevant in relation to Ukraine. So in relation to the tragic shooting down of Malaysian Airlines flight MH17, which was carrying large numbers of both Dutch and Australian nationals, the Netherlands has adopted a number of strategies. So it has commenced proceedings against the Russian Federation in respect of the shooting down of MH17 before the European Court of Human Rights. And it's also initiated and concluded criminal proceedings in absentia in respect of various defendants. And the judgment in those proceedings was handed down by the District Court of The Hague on the 17th of November of this year. In addition to that, Australia and the Netherlands have commenced proceedings before ICAO, the International Civil Aviation Organization, in relation to the shooting down of MH17. And so there are essentially a number of different actions which, again, have potential significance in respect of Ukraine legally in a way that may not be immediately apparent. Now, interestingly, the Russian Federation also brought an action in the European Court of Human Rights against Ukraine in 2021. It was unsuccessful in seeking to get provisional measures. The court refused that. I suspect, I don't know for sure, and I apologize, I should have checked this. Now that the Russian Federation is no longer a party to the European Convention on Human Rights, I suspect those proceedings will not continue. There is no doubt, though, I think Ukraine will proceed with its actions against the Russian Federation because, as everyone would know, in terms of state responsibility, a state ceasing to be party to a treaty doesn't operate retrospectively. And so any state responsibility that Russia may have in respect, for example, of the violation of human rights of the population of the Crimean Peninsula in the period prior to the 16th of September 2022, which is the date at which the Russian Federation ceased to be a party to the European Convention on Human Rights, which itself is a very sad development. Ukraine is entitled to pursue state responsibility prior to that date, and I'm sure it will continue to do that for the reasons actually that this lecture will go on to consider. And then you have, in terms of individual criminal responsibility, you have the ad hoc consent that Ukraine is given. I think it's signed but not yet ratified the International Criminal Court statute, but it has given ad hoc consent to International Criminal Court jurisdiction, and a large number of parties to the International Criminal Court statute have referred the situation in Ukraine to the prosecutor. And investigations are ongoing in respect. And so the court has jurisdiction essentially in the territory of Ukraine in respect of persons of any nationality. So Russian Federation nationals accused of crimes within the territory of Ukraine are well and truly within the jurisdiction of the International Criminal Court in respect of those proceedings, as are, and as should be the case, Ukrainian nationals as well. So, and then we've got non-state entities having brought actions against the Russian Federation. So relying on investor-state dispute settlement provisions in a treaty between Ukraine and Russia, the Russian Federation, various investor-state dispute settlement claims have been brought. And even though this is a corporate entity suing the Russian Federation, issues that are of relevance to the state of Ukraine have essentially been resolved. And we'll see when we look at the European Court of Human Rights jurisprudence that these investor-state dispute settlement actions have actually been significant in relation to the proceedings that have been brought, for example, before the European Court of Human Rights, and potentially will be of significance in the proceedings before the International Court of Justice. All right, so ways in which weaker states use international law when confronted by aggressive, stronger states. In his 2013 Hague Academy lecture, his general course on international law, Judge James Crawford, in the first chapter of that lecture, sort of compared the experience of the Melians at the hands of the Athenians during the Peloponnesian War, and contrasted, that very famous dialogue where the Melians claimed the principle that they were entitled to stay, neutral in the Peloponnesian War, and Athens sort of lectures them and says, "No, don't lecture us about right and wrong. The strong do as they can; the weak suffer what they must." And that's often where despots stop. They don't go on to reflect on what subsequently happened for Athens during the Peloponnesian War. And what Judge Crawford does in his Hague Academy lecture in 2013 is compare the experience of the Melians during the Peloponnesian War with the experience of the people of East Timor, which, if you adopted a realist approach, you would say, well, the people of East Timor would have been doomed to the same fate as the Melians, because the most powerful state in the region, Australia, was fully supportive of the much stronger Indonesian position. The people of East Timor, a very small population. Indonesia's population is significantly larger. The United States was supportive of Indonesia's claim, and one under any analysis that was just focused on power would assume that the people of Timor were doomed. But international law played a role. It wasn't determinative. Judge Crawford argues that it had two effects. The international legal issues related to self-determination kept Timor on the agenda. In a way that, for example, West Papua has not stayed on the agenda, which is a different history. The failure of the process of decolonisation through Portugal to have run its full course kept the position of the Timorese on the international agenda. And then when the political environment was such that Indonesia was open to resolution, international law then played a role in terms of the process by which eventually the people of Timor gained their independence. And we now have, in 2002, the independent state of Timor-Leste. Now, it's a very long period from 1975, when Indonesia invaded the territory of Timor, to 2002. But Judge Crawford's view is clear, and it's one that I think is correct, that international law was not epiphenomenal. It had a role, it had a relevance. This could not be explained simply in terms of pure power relations. Now, in terms of more specifically the position of Ukraine and its strategy, in some ways, I asked my international law class to write an essay on, is Ukraine more likely to be like Melos, or is it more likely to be like Timor? And obviously that comparison is simplistic, but looking at the position of Ukraine, there was an excellent panel discussion that was, with my involvement with the Jessup Moot competition, Professor Harold Coe from Yale University, who was counsel for Ukraine in both ICJ actions, actually, the ongoing action under the Terrorist Financing Convention on the Convention on Elimination of Racial Discrimination, and the Genocide Convention proceedings that are ongoing. He's been counsel in both of those. And he, in this presentation, and I've included the link on the slide, he identifies essentially 5 aspects to what Ukraine is doing in terms of its legal strategy. So he suggests that international law can be used to undermine false factual narratives. It can be used to expose pervasive illegality. And those two, undermining false factual narratives and exposing pervasive illegality, then feeds into a third factor, which is weakening the position of an aggressor, which then feeds into the next point, which is that the weakened aggressor is under more pressure in those circumstances to engage in peaceful resolution of disputes. And that then feeds potentially into increased legal accountability. So again, the way international law is being used here, which has some similarities with Timor's use of international law and the use of international by states supportive of Timor, like Portugal, you see similar tendencies. Now, what I would, a couple of additional points I'd like to make. First of all, in relation to the role of the General Assembly, the indirect role of the General Assembly, obviously it's important immediately to acknowledge the General Assembly's resolutions that are not specifically in relation to the governance of the budget, etc., of the organisation, etc. The general resolutions of the General Assembly are recommendatory, they're not legally binding. But as we all know, that's not the end of the matter. And we know, for example, from the Nuclear Weapons Advisory opinion, that General Assembly resolutions can be important in an evidentiary sense in terms of state practice and opinio juris, but also we know from the Nicaragua decision that resolutions, despite being non-binding, they can be factually relevant. And we can see this in the case law in respect of Ukraine, and I'll give you some examples of this. The other sort of indirect evidentiary impact that I want to just flag for you is the way in which a decision in one context of international law can be relevant in other contexts of international law. And the example that I've used in this slide is the way in which in the Bosnia genocide case, so this is Bosnia-Herzegovina suing Serbia-Montenegro in respect of genocide in Bosnia during the civil war in Bosnia. So it was a state responsibility case, but quite understandably, given the difficulties confronting the International Court of Justice in terms of evidence, the International Court of Justice made it quite clear that it would rely quite heavily on the jurisprudence of the International Criminal Tribunal for the former Yugoslavia. So this is a tribunal set up by the Security Council, which is dedicated to determination of individual criminal responsibility, not state responsibility. And yet, quite naturally, the International Court of Justice, dealing with state responsibility, is relying on the jurisprudence of the ICTY in respect of the issues of state responsibility that the International Court of Justice is dealing with. So you have this indirect effect of one area of international law, individual criminal responsibility, influencing the dispute resolution in another area of international law, that of state responsibility. All right, so now I want to turn to something even less sort of obvious, which is this idea that we're familiar with in national systems, which is that a legal system can affect behaviour indirectly, even involving different parties. So the sort of groundbreaking article in this respect, and this is the idea of the law casting a shadow that affects behaviour of participants within a system. The groundbreaking article here, which was in the Yale Law Journal in the area of divorce, suggested that participants in divorce, where the law is certain, they will adjust their behaviour based on the law when working out property settlement or arrangements regarding access to children, etc. That the law casts a shadow, even in unrelated litigation involving different parties, completely different parties. It affects the way people behave. Now, there is theoretical support for this in the context of international law, but I want to give you an example of a really, I think, clear example of this in my region involving Timor and Australia. You have to bear with me, I'm going to make a digression into the law of the sea here, but I think it's a really clear illustration of how a legal dispute involving completely unrelated parties where it creates greater certainty in terms of the law, that can affect the behaviour of states. And this particular example involves the maritime boundaries between Australia, Timor, East Timor, and Indonesia. And the relevant starting point here is to sort of point out that Australia and Indonesia negotiated their seabed boundary in the 1970s. And Australia successfully persuaded Indonesia that a relevant determination or a relevant factor in the positioning of the seabed boundary between Australia and Indonesia should be the submarine, the underwater depression. It's the Timor Trough, where you have the Australian plate pushing up against the plate that is under Indonesia. And the trough is really close to Indonesian territory. And Australia successfully persuaded Indonesia that should be relevant in the positioning of the border. So the border between Australia and Indonesia is actually much closer. It's not equidistant. It's closer to Indonesia. Now, that was a defensible, I think, a reasonably strong position in the 1970s. But a number of things happened in the 1980s. Two things of significance happened in the 1980s. The first is that the Law of the Sea Convention was negotiated, and the negotiations concluded in 1982, and equidistance or sort of a 200 nautical mile sort of general approach and equidistance when that's not possible was endorsed. And then another thing that happened in a dispute between completely unrelated parties, Libya and Malta, it was argued in the Libya-Malta continental shelf case that a rift, an underwater rift zone between Malta and Libya should be relevant. And the court said, before the 1982 Law of the Sea Convention, maybe, but no longer. With the 1982 Law of the Sea Convention, that is no longer relevant in terms of maritime delimitation. Right? So the basis for Australia's argument in the 1970s was effectively removed by both the 1982 Law of the Sea Convention and the decision in the case of Libya and Malta. And if you look at the resolution of the maritime boundary between Australia and Timor, which occurred in 2018, you see this really quite extraordinary movement of the border, Australia basically having to acknowledge that something closer to equidistance was required to be adopted. So the border with Indonesia remains. It's secured by treaty. It's not able to be impeached. But the boundary between Australia and Timor has been affected essentially by litigation involving third parties and by a treaty in these instances. And that's, I think, an international illustration of how a legal system, and in this instance, international law, can affect behaviour in a way that we are familiar with in national legal systems and perhaps wouldn't have expected in the international context. Now, the other example that I can give you, again, of how certainty or indeed uncertainty in relation to international law can affect behaviour is in respect, again, it's related to Timor. I owe this point to a PhD student's thesis published in the early 2000s. And I'm sorry, the number of words on the slide, I always put too many. But this is essentially from the thesis, but it's an extract of a letter sent by the Transitional Administration of the United Nations for Timor to the Australian government. And essentially, what the UN Transitional Administration is arguing in this passage of this letter, which is being extracted by the PhD candidate, is that the UN having examined the petroleum contracts that Indonesia entered into in respect of the Timor Gap, this area, which prior to 2018 had not been the subject of any delimitation, the UN basically comments that the terms of those commercial arrangements were extremely generous to the companies, the extracting companies that were extracting gas from this region. And the UN transitional administration suggests that the reason why Indonesia got such a bad bargain from the resource companies in this instance was because Indonesia's title, Indonesia's sovereign claim in respect of the Timor Gap was weak. And in a sense, the oil and gas companies essentially were able to argue that that risk, that legal uncertainty in terms of the international legal claim that Indonesia had in respect of the Timor Gap, translated into a risk in terms of the commercial returns, and they use that, according to the suggestion from the UN Transitional Administration, was that these companies use that risk to essentially drive a much better bargain. And so you've got non-state actors using international legal uncertainty essentially to derive a commercial advantage in the context of negotiations for offshore resources. All right, so that's all very interesting. How does all this sort of relate to the position of Ukraine? So going through the various examples I gave. So I mentioned earlier that Ukraine was unsuccessful in its World Trade Organization challenge against the Russian Federation. It was largely unsuccessful. But as I indicated, Australia and other members of the WTO, and including all the G7 members, have essentially used the litigation that Ukraine initiated, that brought certainty in terms of Article 21, the national security exception of the GATT, and used that essentially to invoke national security against the Russian Federation to deprive the Russian Federation of its most favored nation status under the WTO agreement. So you have essentially states that are supportive of Ukraine essentially relying on the unsuccessful litigation that Ukraine brought, but the legal certainty that that litigation generated, essentially to deprive Russia, the Russian Federation, of the benefits of the WTO agreement in quite dramatic terms, and indeed Belarus. Now, this is an ongoing issue, and you obviously have the attempt by, not in the trade context, I think that the trade issues are, in a sense, the traffic in transit case makes the Russian Federation's position quite weak, but investor-state dispute settlement, you can expect a steady stream of oligarchs and others bringing actions against states that are parties to bilateral investment treaties with the Russian Federation for actions we brought. But again, the case law that we have looked at in terms of the ICJ and the European Court of Human Rights decision that we'll be looking at in a moment will, I think, influence the way in which these cases are, the way in which they progress in ways in terms of the shadow of international law that I've been referring to. Now, I mentioned also Ukraine's failure before the Annex 7 arbitration body. This is the maritime delimitation case where the Annex 7 arbitral body under the law of the Sea Convention said it wasn't prepared to, in a sense, rule on the sovereignty of Crimea. It wasn't prepared just to accept the General Assembly resolution. This is the resolution that calls on states not to recognize any alteration of the status of Crimea. This was adopted in 2014. That's the voting pattern for this resolution. In 2020, the arbitral body set up under Annex 7 of the Law of the Sea Convention was not prepared to rule in favor of Ukraine in terms of sovereignty over Crimea. Now, again, that looks like a failure, but if one looks at subsequent case law, one sees attempts to distinguish that decision, the decision involving Crimea, and we see this both in this case before the International Tribunal for the Law of the Sea, involving Mauritius and the Maldives, quite bizarrely, but again, this is the shadow of international law. And we can also see it. We can also see this earlier decision involving Ukraine under the Law of the Sea Convention being distinguished by the European Court of Human Rights as well in its 2021 judgment. More on that in a moment. So let's just say something about how it is that an arbitral body involving Mauritius and the Maldives is offering an opinion on an arbitration involving Ukraine and the Russian Federation. So I need to digress a little bit for this as well. So Mauritius has been in a dispute with the United Kingdom since the 1960s, essentially, over the dismembering of the colony of Mauritius, and in particular, the removal of the Chagos archipelago from the colony of Mauritius, so as to establish the US Air Force Base at Diego Garcia. And Mauritius has been attempting to, I mean, there were efforts made in the General Assembly in the 1960s to condemn the United Kingdom for this action of dismembering the colony before independence. And then Mauritius has brought various actions. It brought an Annex 7 arbitration, which partly ended up like Ukraine's action. It wasn't entirely successful, and the arbitral body wasn't prepared to deal with sovereignty questions involving the Chagos archipelago. But then a request for an advisory opinion was sought by the General Assembly. And in 2019, the International Court of Justice gave an advisory opinion on Mauritius and the Chagos archipelago, and essentially found that the right to self-determination was a right under international law, as at 1965, and the purported sort of severing of, or the breakup of Mauritius, removing the Chagos archipelago, was a breach of international law. And then the General Assembly passed a resolution condemning, essentially, endorsing the advisory opinion and essentially, in substance, condemning the United Kingdom. Now, how does that all play out? Well, subsequently, Mauritius contacted the Maldives and said, let's negotiate our continental shelf. And the Maldives said, well, no, we can't discuss this with you. We think there's a third state involved here, the United Kingdom. And in a judgment in 2021, the International Tribunal for the Law of the Sea said, no, we distinguished the Ukraine-Russian Federation case because there wasn't a judgment of the International Court of Justice. In the Mauritius case, there's now an advisory opinion, which clearly supports Mauritius's claim to sovereignty. And so essentially, the International Tribunal for the Law of the Sea was prepared to discount the United Kingdom's position because it was implausible, completely implausible in these circumstances. And it placed some weight on the General Assembly resolution in respect of Mauritius. So where Ukraine failed, Mauritius succeeded. And while the circumstances are not comparable and while an advisory opinion is not likely, we will see that the case law of the International Court of Justice and the European Court of Human Rights may make a similar argument available for Ukraine in respect of its disputes, its sovereignty over Crimea, for example. Right, so we've got the ongoing litigation involving the Convention on Terrorist Financing and the Convention on the Elimination of Racial Discrimination. We have the Genocide Convention litigation, and we have the European Convention on Human Rights litigation brought by Ukraine vis-a-vis Crimea. And I want to focus on that European Court of Human Rights decision. I think it was actually released in January of 2021, notwithstanding the judgment is dated as 16th of December. And so these are, sorry, I again put too much on the slides, but essentially in the admissibility decision of the European Court of Human Rights regarding the situation in Crimea, essentially, the European Court of Human Rights in these passages is indicating that well prior to the unlawful referendum in March of 2014, from the very movement, the very appearance of the first little green men, to use the language that was used, in February, from the 27th of February, from the very first appearance of these armed personnel in Crimea, Russian control was established. Russia was in effective control from, according to the European Court of Human Rights, from the 27th of February. And they rely on interviews given by President Putin, indicating that he made that decision on the 22nd of February. So you have the European Court of Human Rights essentially saying that Russia was effectively occupying Crimea weeks before the unlawful referendum. Now, in addition, you have an extraordinary factual situation that one of the key sources of evidence as to how it was that Russia gained control in Crimea is one Igor Girkin. He goes under various names, and he was alleged to be a leader of the Crimean Self-Defense Force, which was a paramilitary group, which is, I think, very closely aligned with the Russian Federation. That is the same Igor Girkin who then is found guilty of moving the Buk rocket launcher by the Dutch District Court just recently. And one of the four, I think it was four or maybe five, no, I think it was four defendants, one of the three convicted, in respect of the shooting down of MH17. So what you have is a factual matrix, an argument that this is all a sort of, a movement in Crimea of genuine popular support for the Russian Federation being undermined by findings that Russia has effectively occupied the territory, findings that a person who has previously been heavily involved with the FSB, who was involved in the seizure of premises in Crimea, subsequently going into the Donbass region and acquiring a Buk rocket launcher from the Russian Federation and deploying it in the territory of Ukraine to shoot down a civilian airliner. All of these things suggest that factually, the position is very much not what the Russian Federation would have people believe in terms of the position in Ukraine. Now, moving back to the European Court of Human Rights, you have then the General Assembly resolutions, the ICJ judgment in the terrorist financing litigation, and the bilateral investment treaty cases that have been decided. Basically concluding, and this is quite significant, concluding that the jurisdiction that Russia exercises, the Russian Federation exercises over Crimea is not sovereignty jurisdiction. It's not territorial jurisdiction. It is the jurisdiction that one would exercise if you were an occupying power. It is the jurisdiction of effective control. And so you have, and this is essentially an admissibility finding, so obviously there are still issues of the merits to be decided, but essentially the European Court of Human Rights, relying on General Assembly resolutions, relying on the International Court of Justice decision, and relying on arbitral awards, essentially moving in the direction of treating Russia as an occupying power rather than a sovereign. And going back to the arbitral award under the Law of the Sea Convention that Ukraine lost, again, the European Court of Human Rights is effectively at this passage in paragraph 348 distinguishing that decision and saying, nevertheless, the other facts regarding resolutions of General Assembly and decisions of various courts and tribunals point to this not being territorial jurisdiction, but rather being effective jurisdiction akin to the jurisdiction that one would have in a case of occupation. Right. So, and then you've got obviously in terms of the allegations of expropriation of property in Crimea, the European Court of Human Rights under Protocol 1, essentially relying, not surprisingly, on the bilateral investment treaty jurisprudence in that regard as well. So again, indirectly, non-state entities bringing a claim against the occupying power, the Russian Federation, relying on a bilateral investment treaty, and a human rights court picking that up and using it in terms of state responsibility in the context of the European Convention, and in this instance, the first protocol. And then, again, recall that just recently, the General Assembly has passed a resolution referring to international mechanisms for reparation for Ukraine regarding the aggression, and remembering as well that there is an immense amount of wealth that is currently frozen, sitting in bank accounts around the world, which is potentially available for reparation in respect of the conflict in Ukraine. And in terms of non-state actors, I mentioned the oil and gas companies in the context of East Timor. In terms of the oil cap, I just wanted to just draw, it's a slightly different scenario, but just make the point that in relation to the oil cap, it seems that one of the targets for the oil cap, or one of the focal points for the oil cap is not states per se, but the insurance companies that are insuring vessels that are carrying oil, and the shipping companies that are perhaps unable to secure insurance. And again, we can see how the legal system casts a shadow in a way that affects non-state entities in a manner that may be of benefit to Ukraine in its dispute, in response to Russia's aggression. All right, so that, I'm sorry if I've gone over time. Essentially, that is where I would like to finish. I just wanted to make just a number of really brief concluding observations. First of all, just to recommend, if you haven't had a chance to watch it, the Kenyan ambassador in the Security Council speaking just after the invasion of Ukraine, and pointing out that Posidatis, the reverence for international borders is something that is incredibly important, not just in Europe, but also in Africa. And the Russian rhetoric in relation to Crimea is, oh, it was transferred by Khrushchev without regard to circumstances. And the response from the Kenyan ambassador is, well, our borders were drawn in Berlin and in Brussels and in London. But we can see that fratricidal conflict is the consequence that we would suffer if those borders were reopened. So that's the first point. The second point is, in terms of concluding observations, I mean, the prospects for the world if Ukraine fails in its legal challenges and in its military action, in its defense, are really quite dire. They are dire in terms of the risks of conventional arms races, in terms of borders becoming unstable. They are dire in terms of the potential for acquisition of nuclear weapons to be seen as a way of protecting states that are worried about their neighbor coveting their territory. I was at a function yesterday where a Ukrainian lawyer set out, the main problem for Ukraine was giving up its nuclear weapons in the 1990s. If Russia succeeds, that may be the lesson that many states draw from the conflict in Ukraine. And then you've got the diabolically bad consequences of increased spending on military resources and the way that will divert vital resources from health and education and all manner of other things. And so for me, I went to Ukraine in 2018 to teach a group of students in preparation for the Jessup Moot competition, and I met bright, hard-working students who are now serving in the military, defending their homes and their families. And so it has a personal dimension for me. But as an international lawyer as well, I think this is an existential threat to international law, which the legal strategy employed by Ukraine is a potential response to. I might leave it there. Thank you.
Thank you warmly, dear Professor, for this very interesting lecture. And I'd like to open our discussion round. I do have a couple of questions actually, but I'd rather don't be the first one to go. So, dear ladies and gentlemen, are there any questions from your side to our dear Professor Cassimatis here? We also have a good share of Portuguese people here, so maybe a question about East Timor.
East Timor, yes.
Seems in the first place not to be the case, maybe later. Then, okay, I might as well start. Dear Professor, you mentioned, among other elements, also the EEZ boundary treaty between Australia and Indonesia of 1997 not yet being in force.
Mm-hmm.
And you also mentioned Malta and Libya in the same regarding comparable topics. And given the ongoing difficulties of Greece, for example, to be able to come to a mutual agreement with its neighbors regarding especially the matters of the exclusive economic zone. Well, I'm not going to ask you to assess quickly the the UN law of the sea, but do you think that there is some need of revision of the parts of the UN Convention regarding the law of the sea, especially in respect to the matters of exclusive economic zones? Obviously, there are problems for many countries to be able to come to such agreements. What do you think?
Yes, I mean, obviously, it's extremely difficult in the Mediterranean. Timor is currently in the process of negotiating its maritime boundaries with Indonesia, which are far more complex given the northern areas. So similar issues. I mean, I'm not a law of the sea expert, so I'm not really in a position to comment on what particular reforms would be appropriate. I would say, though, that the capacity of legal rules to cast a shadow is, one factor, but there are a range of other factors that affect the potential for rules to operate that way. So the preferences of the parties in the dispute and how seriously they take the issue is extremely important. So obviously, the issue of Turkey's attitude towards offshore resources and Greece's attitudes, the degree of certainty of the rules. So if they're not particularly clear, that's going to affect things. And then, in terms of if there's some uncertainty, risk aversion on the part of the parties to the dispute are all potentially relevant factors. So I am not suggesting that, for example, in the case of Vladimir Putin and the Russian Federation, the Russian Federation's contested claims over Crimea may make it hard for the Russian Federation to receive direct investment in respect of Crimea, but it may not care. It may be so committed to maintaining its claim that it's prepared to absorb the costs associated with that. So legal systems do influence behavior, but they also have, they're just one factor, and they can be inadequate, as the example you gave, I think, does reflect. And the preferences of the parties can also affect the costs they're prepared to incur and the difficulty you might have. I mean, again, Timor, the poor Timorese had to wait from 1975 to 2002, sort of over 25 years for independence. So it was a tragically long period for international law to function. So.
Thank you warmly. Dear ladies and gentlemen, what about now, in the meantime? Are there any further questions from your side? I would have another one, as a matter of fact. I don't mean to be fatalistic in any way, but sometimes when I teach international law in my lectures, I come very often to a point in which I would have to tell my students, okay, dear ladies and gentlemen, so much about the theory, and in praxis, there are certain difficulties regarding matters of executing international law. So at the end of the day, what would you tell your students actually at the finish of an international legal class? Because, okay, obviously there is a quite huge instrumentarium of elements which international law provides. But at the end of the day, one seems to be in the hands of the more powerful nations of this earth. So what do you think at the end of the day?
Look, I agree, and I do share that pessimism, which I always have to remind myself. The last living Nuremberg prosecutor, Benjamin Ferencz, who has a number of catchphrases. One of them is never give up. And the other is it takes courage not to be discouraged. And I would say, first of all, permanent members of the Security Council behaving badly is a given. And the example that I would give of that, not that we need more examples, but the example for me that I think comes reasonably close to the current crisis is the Suez crisis in 1956, where you have the British and the French essentially tearing up the charter and invading Egypt in respect of the Suez Canal. And they eventually were humiliated and withdrew. And that process of humiliation and withdrawal, it happened. They withdrew and Egypt's sovereignty was restored over the Suez Canal. And so people tend to focus on more recent failures of the system, and those failures are givens, but that failure indicates that permanent members of the Security Council don't always get their way. And where you have states realizing what is at stake by the aggression against Ukraine in terms of territorial certainty, boundaries being, in a sense, ripped up, in terms of a powerful state essentially just attempting to seize territory from a smaller, weaker state, you have the potential for other like-minded states, other states that aren't extremely powerful, in a sense, to band together. And then you've got the tools that international law gives us in terms of unilateral sanctions. Now, that's a topic in itself, but the Magnitsky Act sanctions, the various actions freezing assets, which, I mean, legally it's anarchical perhaps, but it's one of the sort of points of this lecture. The certainty factually and the certainty legally that Ukraine's strategy is producing is going to feed into all of the investor-state dispute cases and all of the various national legal challenges that are brought by oligarchs in respect of the seizure of assets. And so, you know, I mean, that's on the practical level. On the sort of normative level, I still have faith in the wisdom of the drafters of the United Nations Charter. I think that that there is no viable alternative, certainly not for a state like Australia. The commitment to coexistence, the commitment to cooperation and the commitment to substantive values in the form of human rights, there is really no viable alternative. And I think that, in a way, the aggression against Ukraine has demonstrated that there is no viable alternative. And so I'm going to stick with the glass half full position rather than the glass half empty, I think. And that's what I tell my students, essentially, that substantively the rules are worth defending. And I think, sort of bizarrely, the aggression, in the same way that NATO expansion has occurred with Finland and Sweden joining NATO potentially, the unintended consequences of the aggression are such that maybe international law has been reinvigorated. The reason for it has been quite clearly restated by Russia's aggression.
Thank you very much. So, dear ladies and gentlemen, last chance now. Any further questions, maybe, from your side?
I did range across a broad range of issues, so I hope my explanations were clear in terms of the different areas that I covered. So.
Perfectly, it went perfectly well, and it showed actually the considerable wealth of instruments which the international law provides. So I'm pretty sure that our participants gained a lot of this lecture, and
yes.
Well, since I don't see any further questions, I'd rather suggest that we, I was particularly intrigued by the very strong saying of it takes courage not to be discouraged. And well, let's leave it there. It's quite, it gives an optimistic view as well as the the glass half full, let's say. So I'd like to thank you warmly for your lecture. It was very interesting and our participants gained a lot. And I'd like to wish you, of course, all the very best. And I'm pretty sure that we're gonna see each other again in this lecture series, because the lecture was really, really impressive, mirroring the considerable wealth of international law. I'd also like to thank my dear colleague Andrea for providing the virtual room as always. And I'd like to thank our participants warmly for their interest and the participation. So thank you all, and
thank you.